Hello friends, welcome back to the series of lecture. This is the 10th lecture of the series of Indian Evidence Act. In this lecture we would continue with section 92. So 91 tells you that in a certain matter if you are having a document and you have oral evidence also, and if the conditions of section 91 are fulfilled, then only the document evidence will be allowed and the oral evidence will not be allowed. And once the documentary evidence are proved, then that documentary evidence will be final. Now, suppose A and B entered into a contract and they documented it. Now, that documentary evidence has to be proved under section 91. Now, suppose after the documentation of the contract, A and B entered into a oral agreement and changed certain terms of the contract. For example, uh, earlier the consideration was 50 lakh rupees and now after orally they agreed to change it into 70 lakh rupees. अब द पॉइंट इज जो आपने पहला एग्रीमेंट किया है, कॉन्ट्रैक्ट किया है, सो अर्लियर कॉन्ट्रैक्ट वाज डॉक्यूमेंटेड, सो व्हेन यू चेंज द कॉन्ट्रैक्ट लेटर ऑन दैट शुड आल्सो बी documented, but you have not documented it. So once you have proved that contract by the document, and suppose the contract is between A and B. Now later on A says that the consideration amount was altered by the oral agreement 50 lakhs to 70 lakh. Then will the evidence, oral evidence of that oral agreement will be allowed? So on that the answer is given in section 92 and it says no. 92 talks about the conclusivity of the documentary evidence की conclusivity के बारे में 92 बात करता है, and 91 talks about the exclusivity of the documentary evidence. So write this sentence. Section 91 is about exclusivity of the documentary evidence, whereas 92 is about the conclusivity of documentary evidence. So when you say exclusivity, then that means that only documentary evidence can be proved. Exclusive. Documentary evidence exclusive can be proved. Oral evidence will not be allowed. So that is exclusivity. And conclusivity means that once the documentary evidence had been able to prove of the said contract, etc., then after that, that is final, and any oral evidence after that for the alteration and change will not be allowed. And if you want to prove the change in the contract, that has to be proved by the document only. That is, once the document had been proved, now oral evidence to prove the changes in the transaction will not be permissible. If there are any changes, then that also should have been documented. And if you not have documented, oral evidence will not be allowed for that purpose. Then write down exclusivity means that only the documentary evidence for the transaction can be proved, whereas conclusivity relates to the fact that once the transaction has been proved by documentary evidence, any changes in the terms of the transaction also shall be proved by documentary evidence only, and oral evidence shall not be allowed for that purpose. Now see section 92. When the terms of any contract, grant or other disposition of property or any matter required by law to be reduced to the form of a document. So that covers the entire thing which is in 91. Contract, grant or other disposition of property or any other matter required by law to be reduced into writing. When the terms of any such contract, grant or other disposition of property or any matter required by law to be reduced to the form of a document have been proved according to the last section. That is section 91. No evidence of any oral agreement or statement shall be admitted as between the parties to any such instrument or their representatives in interest for the purpose of contradicting, varying, adding adding to or subtracting from its terms. So means what they are talking about here is there was a contract, grant, disposition, or any other matter required by law to be reduced into writing, and the terms of that contract, grant, disposition, or in that matter have been proved by section 91 have been proved under section 91 by a document. And once 91 that has been proved by document, and now if you suggest that the terms were altered by oral agreement, altered by an oral agreement or a statement by either of the party, then that will not be allowed to be proved. If there was any alteration, then obviously when you document the transaction, then any changes in the transaction shall also be documented. And if you not documented it, then the section is strict, subject to the proviso obviously. The section is strict and clearly says कि किसी भी ओरल एग्रीमेंट या स्टेटमेंट को ओरल एविडेंस के द्वारा प्रूफ नहीं किया जा सकता या ओरल एविडेंस उस पर अलाउ नहीं होगा। अब देखिए कोई एग्रीमेंट हुआ ओरल तो उसका ओरल एविडेंस होगा, या स्टेटमेंट हुआ तो उसका ओरल स्टेटमेंट का भी oral evidence होगा. So oral evidence of any such statement will not be allowed. फिर से देखिएगा, when the terms of any such contract, grant or other disposition of property or any matter required by law to be reduced to the form of a document have been proved according to the last section. So here we are presuming that section 91 applied and the document was proved. To the last section, no evidence of any oral agreement between the parties or a statement by any of the parties. No evidence of any oral agreement or a statement shall be admitted as between the parties. थर्ड पर्सन्स की बात नहीं कर रहे हैं हम यहाँ पे जो ऑल्ट्रेशन की बात कर रहे हैं हम, दैट इज बिटवीन दोज पार्टीज, और उन पार्टीज के बीच अगर सूट होगा एंड देयर दे वांट वन ऑफ देम wants to prove the oral evidence, that will not be allowed. If a third person is involved, then the section 91 is not apply. 91 applies only as between the parties. तो थर्ड पर्सन की बात हम यहाँ पर नहीं कर रहे हैं, यहाँ पर जो अल्ट्रेशन की बात कर रहे हैं उन पार्टीज के बीच की बात कर रहे हैं। अगर उन पार्टीज के बीच सूट होगा and there if they wants one of them wants to prove the oral evidence, then that will not be allowed. If the third person is involved, then the section 91 will not apply. 91 applies only as between the parties. Suppose if there is conflict between the parties, one of them prove the document, written document, and one of the parties says that I want to prove the oral evidence for the alteration of the terms, then for that oral evidence will not be allowed. But किसी थर्ड पर्सन से अगर सूट हो जाए उसी ट्रांजैक्शन से रिलेटेड तो 92 नहीं लगेगा, because 92 clearly writes as between the parties. So no evidence of any oral agreement or statement shall be admitted. Shall be admitted means what? Allowed to be proved in evidence. No evidence of any oral agreement or a statement shall be admitted as between the parties. As between the parties means that if the parties to the transaction are in a civil suit, then in that case the oral evidence will not be allowed to be proved to any such instrument और their representatives in interest। सो इसमें अगर पार्टी ना भी हो, पार्टी में से कोई मर गया है और उसका कोई लीगल रिप्रेजेंटेटिव है और वो सूट में इन्वॉल्व है, तब भी द प्रूफ विल नॉट बी अलाउ। फॉर एग्जाम्पल, सपोज कॉन्ट्रैक्ट वॉज एंटर्ड बिटवीन ए एंड बी। अब कॉन्ट्रैक्ट ए और बी के बीच में हुआ है। लेटर ऑन सपोज ए डाइड्स एंड हिज लीगल रिप्रेजेंटेटिव सम सी टेक्स हिज प्लेस एंड देयर इज अ सूट बिटवीन ए एंड बी। अब सूट करने के बाद जो सूट चल रहा था ए एंड बी के बीच में, इनिशियल स्टेज पे ए मर गया, सी इसकी प्लेस पे आ गया। नाउ दिस इज द सूट बिटवीन सी एंड बी। सो दिस इज द सूट बिटवीन सी एंड बी। अब सी ऑन द बेसिस ऑफ डॉक्यूमेंट प्रूव द कॉन्ट्रैक्ट। Now B wants to give evidence of some oral agreement that after the original contract between me and A had entered into an oral agreement and altered the terms of the contract, then this will not be allowed. So जो A और B के बीच में सूट होता, मान लो A नहीं मरता, तब भी अलाउड नहीं होता। अब मान लो ए मर गया और सूट बाद में डायरेक्टली भी सी और बी के बीच में हुआ, एक लीगल रिप्रेजेंटेटिव और बी के सूट डायरेक्टली सी और बी के बीच में हुआ, तब भी ओरल एग्रीमेंट अलाउड नहीं होगा। और मान लो बी भी मर गया, उसके लीगल रिप्रेजेंटेटिव, और ए भी मर गया, उसके लीगल रिप्रेजेंटेटिव के बीच में सूट है, तब भी ओरल एग्रीमेंट अलाउ नहीं होगा। लेकिन अगर कोई थर्ड पर्सन है इसके अलावा, then section 92 will not apply. उसके लिए we have section 99 which we have talked about. So here the terms of contract altered by oral agreement will not allowed to be proved. So read the section once again. When the terms of any such contract, grant or other disposition of property or any matter required by law to be reduced to the form of a document have been proved according to the last section, no evidence of any oral agreement or statement shall be admitted as between the parties to any such instrument or their representatives in interest for the purpose of contradicting. Contradicting means what? Whatever there is written in the document, उस पर opposite कुछ proof करना, to contradict that, और varying, जो लिखा है डॉक्यूमेंट में उसमें कुछ चेंज हुआ था, वेरिएशन, और adding some more term orally. Some terms are written in the document and some more terms are added orally. Or subtracting means the terms which are written, out of them two or one whatever terms we have removed by oral agreement. So any such change by addition, by variation, by subtracting, etc., or by contradiction will not allowed to be proved. So any such change by contradiction, varying, addition or subtracting, etc. will not be allowed to be proved by oral agreement. Means oral evidence is not allowed on. अब उसके बाद you have these proviso in which the court allows to prove the oral agreement. proviso को बाद में देखेंगे, पहले section 99 देखते हैं। Persons who are not parties to a document. Persons who are not parties to a document or their representatives in interest may give evidence of any fact tending to show a contemporaneous agreement varying the terms of the document. Persons who are not parties to a document. अब ये नॉन पार्टीज की बात कर रहे हैं। मान लो कॉन्ट्रैक्ट था ए और बी के बीच में, एंड देयर इज ए पर्सन सी, ही इज नॉट अ लीगल रिप्रेजेंटेटिव, ही इज जस्ट ए पर्सन सी। Persons who are not parties to a document or their representative in interest. अब ये सी ना तो उस कॉन्ट्रैक्ट का पार्टी था और ना ही उनमें से, उन पार्टियों में से किसी एक का लीगल रिप्रेजेंटेटिव था। Person who are not parties to a document or their representatives in interest may give evidence. May give evidence. So this is permissive. Enabling. May give evidence of any facts tending to show a contemporaneous agreement varying the terms of the document. मतलब अगर कॉन्ट्रैक्ट ए और बी के बीच हुआ था और उसके टर्म्स लिखे गए हैं, अब immediately after the contract, contemporaneous means what? Side by side, or immediately after the contract. So continuity of the transaction. So there was a contemporaneous oral agreement between A and B. This is oral agreement, and this oral agreement between A and B has altered the terms of this contract. So this oral agreement between A and B has altered the terms of this contract. अब कोई भी टर्म समझ लो आप, मान लो कोई एग्रीमेंट था बिटवीन ए एंड बी, 50 लाख का था, कंसिडरेशन अमाउंट वाला एग्जांपल ले लेते, ए एंड बी के बीच में 50 लाख का कॉन्ट्रैक्ट था। अब उसको कंटेम्परेरियसली एग्री करके 50 को 60 लाख कर दिया, या 50 को 20 लाख और बढ़ा दिया तो 50 को 70 लाख कर दिया, 20 लाख कंसिडरेशन अमाउंट बढ़ा दिया था। अब कैन दिस एग्रीमेंट, ये जो बाद में ओरल एग्रीमेंट हुआ है, एज पर वट एवर देयर इन 92, कैन दिस एग्रीमेंट बी प्रूव्ड बाई ए एंड बी? द आंसर इज नो, बिकॉज एज पर 92 that will not be allowed unless it is not fall in any of the proviso. अब proviso की हम बात नहीं कर रहे, and we do not know the proviso right now. अब can it be proved by C, the third person? If it was a contemporaneous oral agreement, they are not saying subsequent, it is a contemporaneous oral agreement. They are saying contemporaneous oral agreement means parallel to the written document. Parallel to the written document, maybe immediately after they have entered into a oral agreement to alter the terms of the contract, then C can prove the alteration by proving the oral agreement. लेकिन अगर A और B के बीच में सूट हो तो नहीं कर सकते। पर यहाँ पर C कौन है? C is a third person. ध्यान रखना, ए और बी के बीच सूट नहीं है, एक और बी के बीच में सूट है होगा तो नहीं प्रूव कर पाओगे, तब तो सी विटनेस की तरह भी अपीयर नहीं हो सकता। बट अगर सूट ए और सी के बीच हो जाए या बी और सी के बीच हो जाए, यहाँ पर चेंज कर लेते हैं, ए की जगह सी कर देते हैं, तो सूट अब ए और बी और सी के बीच है, और या फिर सूट हो जाए ए और सी के बीच में regarding that contract. Which contract? Which is between A and B. अब how it is maintainable? Because C is a third party, it is a stranger to the contract. That we have to understand. But if there is any suit, then C will be allowed to give the evidence of the alteration. अगर A और B के बीच में सूट है तो 92 लगेगा, लेकिन अगर A और C के बीच सूट है या B और C के बीच सूट है, तब अगर कंटेम्परेरियस एग्रीमेंट था तो 92 नहीं लगेगा। 99 में द थर्ड पर्सन विल बी अलाउड टू प्रूव द ओरल एग्रीमेंट। सो इलस्ट्रेशन देखते हैं इसका। Persons who are not parties to a document or their representative in interest may give evidence of any fact tending to show a contemporaneous agreement varying the terms of the document. Illustration: A and B make a contract in writing that B sell A certain cotton. A और B के बीच में agreement है that B will sell cotton to A, and the price may have been fixed for that to be paid for on delivery. So he deliver the cotton, then only the price will be paid. At the same time, they make an oral agreement that 3 months credit shall be given to A. Now you see that the document says that whenever the delivery is made by B, A shall make the payment there and then. But parallelly they have entered into an oral agreement कई बार ऐसा होता है कि डॉक्यूमेंटेशन कर लिया, लिख लिया, साइन कर लिया, लेकिन वहीं पर पार्टी ने इंसिस्ट किया कि तुरंत पेमेंट तो मुश्किल हो जाएगा, थोड़ा सा टाइम दे दो मुझे। तो दूसरी पार्टी ने कहा ठीक है मैं वैसे ही दे देता हूँ, 3 महीने का टाइम दे देता हूँ, लेकिन वो ऑरली हुआ है, लिखा नहीं है। 3 महीने का टाइम दूंगा, दैट इज नॉट रिटन, तो 3 महीने बाद तुम पेमेंट करना, एंड दैट इज एन ओरल एग्रीमेंट, इट इज नॉट ए रिटन डॉक्यूमेंट। एट द सेम टाइम they make an oral agreement that 3 months credit shall be given to A. This could not be shown as between A and B. If A and B contest the suit, then this oral agreement cannot be proved unless it is fall into any of the provisos. But it might be shown by C if it affected his interests. Now, this third person C, somehow he gets affected by that contract and there is a suit between A and C. किसी तरीके से अगर C अफेक्ट हो रहा है उस कॉन्ट्रैक्ट से और सूट हो गया A और C के बीच में, then C can always prove that there was an oral agreement to give that much of time, the credit. Now let's take an example. Suppose A और B दो parties हैं. These are two parties to a contract, and the agreement is that B will do something to A and A will pay the price. So B have to sell the house or whatever and A have to pay the price. B का consideration है और A will pay the price. अब if you have read privity of consideration of privity of contract in the contract act, नहीं पढ़ा होगा तो मैं डिटेल में पढ़ाऊंगा, then you will understand that the agreement may be like this, that consideration will be given by B but price of it will be paid by C. So C is the stranger to the contract but he is the beneficiary in the contract. Means A और B के बीच में B will pay the consideration to the A. In this example B will giving the consideration, whatever consideration, house, land, and A will give consideration to the C. C will be considered to be beneficiary. And now you may have read into the law of contract that C is the stranger to the contract and therefore he cannot file a suit for the benefit. But if a charge is created in favor of C with respect to some property, etc., then you may have ever read the Tweddle versus Atkinson case in the law of contract, wherein the exceptions are created, and one exception ही is अगर C के फेवर में कोई चार्ज क्रिएट कर दिया A ने, तो उस केस में ये जो C है उसको राइट मिल जाएगा सूट करने का. अब ओरिजिनल जो डॉक्यूमेंटेड कॉन्ट्रैक्ट था उसमें द अमाउंट वाज 50 लाख रुपीस सपोज. अब साथ साथ ओरल एग्रीमेंट कर लिया इन लोगों ने कि 20 लाख रुपए और बढ़ा देते हैं, 70 लाख रुपीस कर लेते हैं. अब A C को पेमेंट नहीं दे रहा है या फिर पेमेंट दे रहा है तो सिर्फ 50 लाख रुपए दे रहा है. अब C ने सूट कर दिया A के ऊपर दैट द कंसिडरेशन अमाउंट एज पर द oral agreement is 20 lakhs more. Now here C was not a party to the contract, neither he is representative in the interest. If the suit was between A and B alone, then that 20 lakhs would not be able to prove because that was oral agreement. But C is a third person, so as per section 99, if it was a contemporaneous agreement to increase the consideration amount, then C for his interest can file suit against A as per the laws in the Contract Act, and he can always prove the oral agreement contemporaneously take place. एक बार फिर देख लेते हैं इस एग्जाम्पल को. What I said was A और B के बीच को एक कॉन्ट्रैक्ट हुआ. B was proposed to give some consideration to A, and the agreement was that you don't pay the money to me, you pay the money to my brother or my son, whatever, C. अब एज सच सी इज नॉट ए रिप्रेजेंटेटिव इंटरेस्ट। अब सी के बेनिफिट के लिए उसने कह दिया कि कंसिडरेशन अमाउंट तुम देना, जो 70 लाख आपको देना है, लेकिन वो एक बार में देने की जरूरत नहीं है आपको, तुम्हारे जो मकान का किराया आता है उसके थ्रू मंथली इंस्टॉलमेंट्स में दे देना। दैट इज व्हाट मीन बाय चार्ज। सो ए एट द हाउस इन विच ए क्रिएट द चार्ज इन फेवर ऑफ सी एज पर द एग्रीमेंट। अब जैसे ही चार्ज क्रिएट होगा इन द कॉन्ट्रैक्ट एक्ट, सी बिकम्स एंटाइटल्ड टू फाइल द सूट। अब ये आपने कॉन्ट्रैक्ट पढ़ा होगा तो आपको समझ में आ जाएगा, बट फॉर नाउ जो मैं बता रहा हूँ, सी इट। अब व्हाट हैपेंस इज ए गिव्स ओनली 50 lakh rupees to him, not in one go. He said that I will give you 50 lakhs and accordingly you will fix the installment. Now she knows that there is a contemporaneous oral agreement of 20 lakh rupees more. Now she wants that 20 lakh rupees also and A refuses to give that. Now the C files a suit against A. Now this is not the suit between the parties to the contract, but as per the Contract Act, C is entitled to file a suit. Even for the stranger to the contract, the rule of privity says that the stranger cannot file a suit. But since that the benefit was created in the form of a charge, as per the separate sections of the privity, this suit can be filed. अब एक बार उसने जब सूट फाइल कर दिया, A would prove the documents. A produced the document and said that document says that I should pay 50 lakh rupees. Why should I pay 20 lakhs more? Now she says that I want to prove the oral agreement, a contemporaneous oral agreement, in which the amount of 20 lakh rupees was agreed upon. 20 lakh rupees more was agreed upon. Can he give that evidence, oral evidence? That is the question. And the answer is yes. अब अगर A और B के बीच में सूट होता, then that evidence will not be allowed unless obviously it will fall any of the provisos. अब इस एग्जाम्पल पे लिख लो आप, write down, in the present case if the suit was filed by C against A, comma, which he could do even though he is the stranger to the contract as per the law of contract, then the restriction of section 92 will not apply, as C is not a party to the contract, nor he is a representative in interest. As per section 99, C being a outsider to contract, C can always give the oral evidence to prove any contemporaneous oral agreement between A and B to alter the terms of contract. Here, the interest of C is being affected, as he is entitled to the consideration amount and therefore he can prove the oral agreement. अब ये एग्जाम्पल मैंने इसलिए दिया क्योंकि जब कॉन्ट्रैक्ट ए और बी के बीच में है तो क्वेश्चन उठता है कि सी का इंटरेस्ट कैसे क्रिएट हो जाएगा. When there is a contract between A and B, then how can the third person C will be involved? His interest is created. उसको समझाने के लिए we have take the example, as there can be the cases where the C's interest get affected, and one example is this we have discussed, that B give the consideration and the consideration will be given by A to C and for which the charge has been created. Now get back to the section 92. अब 92 में main paragraph we have read. Now we have to see the provisos. And in the provisos there are certain situations wherein, despite the prohibition of the main paragraph, between the parties, we are talking here between the parties, the oral agreement can be proved if the conditions of the provisos are fulfilled. So there can be oral agreement between the parties, or there can be oral statement made by either of the parties, or it may be a circumstance also. Now, agar any of the parties committed the fraud, then can the other party prove that the fraud was committed? If the other party made a statement which is a statement of misrepresentation, and by that he entered into the contract, can the other party prove the misrepresentation by proving that oral evidence? Then obviously the answer is yes. Now see the first proviso. Any fact may be proved. Any fact may be proved which would invalidate any document, or which would entitle any person to any degree or order relating thereto, such as fraud, intimidation, illegality, want of due execution, want of capacity in any contracting party. Want of capacity in contracting party was minor, unsound, etc. Want of want or failure of consideration or mistake in fact or law. These are what? These are situations. These are the situations where in the under the contract made to be voidable. These are all situations where under the contract act made voidable, made to be voidable, or it may render the agreement to be void. अब इस काइंड का सिचुएशंस ऑब्वियसली इनको प्रोवाइजो में लिखने की ज़रूरत भी नहीं थी. अगर आप प्रोवाइजो में नहीं भी लिखते तब भी. अब सपोज एक कॉन्ट्रैक्ट हुआ है एंड वन ऑफ द पार्टी हैज कमिटेड द फ्रॉड अगेंस्ट द अदर. दैट कॉन्ट्रैक्ट इज voidable, and even if you have not written that into the proviso, the act of fraud, the statement related to the fraud or the conduct related to the fraud will always be proved to prove the voidability of the contract. That is the first proviso. So any such transaction, any such conduct, any such statement which may result into the agreement becoming void, just a mistake by fact by both the parties. Section 20 Contract Act, agreement is void or not? Mistake of fact दोनों parties का हो गया, agreement is void. Misrepresentation, fraud etc कर दिया, contract is voidable. So in that ways, इस तरह के जो fact हैं उसके लिए तो आप oral agreement दे ही सकते हो, oral evidence दे ही सकते हो आप उसके लिए. So that is the first point. So see it again. Any fact may be proved which would invalidate any document or which would entitle any person to any decree or order relating thereto, such as fraud, intimidation, illegality, want of due execution, want of capacity in any contracting party, want or failure of consideration or mistake in fact or law. अब ये डिटेल्स तो आपको कॉन्ट्रैक्ट एक्ट में पड़ेगी, व्हाट मीन्ड बाय ऑल दिस. But it says that the transfer rendering the agreement void or contract voidable then always be proved by either of the parties by giving oral evidence also. Now the next. The existence of any separate oral agreement as to any matter on which a document is silent and which is not inconsistent with its terms may be proved. You see, there is a contract. I am talking about contract. It can be grant, disposition, whatever. Now, suppose there is a contract. Now, obviously, when the party entered into a contract and when they documented it, then the intention is to make the document elaborately and to put in all possible points clearly. Parties का जो intention होगा वो ये रहेगा कि सारे points आप clear लिखो, क्योंकि कई बार क्या होगा, the parties are more casual in writing the points and they miss one or two points. एक दो points पर documents may be silent. अब जिस point पर document silent है, अब मान लो जैसे agreement किया between A and B and it was agreed that A will pay B 25 lakh rupees. अब the document is silent as to whether the payment is done by check or by cash, or some portion is by check or some portion is by cash, that is silent. लेकिन उसके लिए on that point there is a parallel oral agreement that 50% is by check and 50% by cash. अब the document is not a very extremely peculiar document on every point, clear document on every point. It is silent on something, and on that silent wala point there is a oral agreement, and that agreement is not inconsistent with the contract. आपने एग्री किया कि 50% चेक से लेंगे और 50% कैश से लेंगे. अब वो कॉन्ट्रैक्ट से इनकंसिस्टेंट तो नहीं है. सो इन दैट केस द ओरल एग्रीमेंट विल बी अलाउड टू बी प्रूव. बट अगर मान लो डॉक्यूमेंट कोई एक्सट्रीमली फॉर्मल है, कोई ऐसा डॉक्यूमेंट है जिसमें हर चीज लिखी हुई है, हर पॉइंट लिखा हुआ है, एवरीथिंग इज रिटन इन डिटेल्स, like you talk about insurance contracts. In insurance contract, everything is written in details. Every bit of the point is written in there in insurance. So that is an extremely formal document. So वहाँ पर you cannot say that the document was silent upon something. If it was silent, then you say that it was intentionally silent, and therefore there cannot be an oral agreement regarding that to be allowed to be proved. ना तो हो सकता है और ना उसके लिए oral evidence दिए जा सकते प्रूव करने के लिए. And in those kind of cases, this proviso will not apply. If the document is extremely formal, then this proviso will not apply. This proviso too will apply only when the document was informal, not very detailed, and some points are missing. And on those points, if there is an agreement, and that agreement is not inconsistent with the broad purpose of the contract. अब मान लो कि एग्रीमेंट है कि मैं 20 लाख रुपए दूंगा, बट आई विल गिव 20 lakhs इफ आई वुड विन इन गैम्बलिंग. तो वो गैम्बलिंग में जीत कर मैं तब पैसे दूंगा. ये ओरल एग्रीमेंट बाद में कर लिया. 20 लाख कैसे दूंगा इसके लिए. सो ऑब्वियसली दैट इज अगेंस्ट द पब्लिक पॉलिसी. या फिर मैं ऐसा एग्रीमेंट कर लिया, मैं बैंक में डाका डालकर दूंगा और अगर सक्सेसफुल हो गया तब दूंगा. सो ऑब्वियसली दिस आर अगेंस्ट पब्लिक पॉलिसी, तो इसको आप प्रूव नहीं कर सकते. Read it once again. The existence of any separate oral agreement as to any matter on which a document is silent and which is not inconsistent with its terms, may be proved. In considering whether or not this proviso applies, the court shall have regard to the degree of formality of the document. So, if the document is highly formal, then this proviso will not apply. Write down on this proviso. Proviso 2 applies only when the document is not extremely formal and it is silent on some point which was essential to contract. And on that point which was essential to the contract, and on that point there is an oral agreement between the parties. If it is found that the terms of such oral agreement are not inconsistent with the broad spirit of the main contract, then the oral agreement can be proved. However, if the document was highly formal, then the intention of the parties was to reduce every point in writing, and therefore, even if it was silent on some point, it was deliberate. It was considered to be deliberate silent. It was deliberate silence, and there cannot be expected an oral agreement on that point. There cannot be expected an oral agreement on that point, and therefore, even if there is an oral agreement on that point, it cannot be proved. What we have seen is two provisos. एक तो proviso है जहाँ पर इन्होंने fraud एक्सेट्रा की बात की है, सो इसमें कोई भी ऐसा ट्रांजैक्शन, कोई भी ऐसी बात, कोई कंडक्ट जो इस एग्रीमेंट को वॉइड डिक्लेयर करता हो या कॉन्ट्रैक्ट को वॉइडेबल बनाता हो, मीन्स उसकी लीगलिटी को अफेक्ट करता हो, तो उसके लिए यू आर फ्री टू गिव एविडेंस। एंड इवन इफ इट इज नॉट रिटन इन टू द प्रोवाइजो यू कुड डू दैट, क्योंकि इसमें ऐसा है, आई जो कॉन्ट्रैक्ट होगा तो वो इस तरीके से पढ़ा जाएगा, आई एग्री टू दिस कॉन्ट्रैक्ट और एग्रीमेंट बिकॉज ऑफ दिस फ्रॉड। तो उस सिचुएशन में एग्रीमेंट वॉइड होगा या कॉन्ट्रैक्ट वॉइडेबल होगा, फिर भी दिस प्रोवाइजो मेक्स इट क्लियर कि उस सिचुएशन में यू कैन डू दिस। Now the second proviso says that if there is an agreement but it is silent upon some point, and on that point upon which it is silent, if there is an oral agreement, then that oral agreement can be allowed to be proved if it is not totally inconsistent with the contract or agreement. That oral agreement will not be inconsistent with the terms of the main agreement. So this is the first condition out of two. Where oral evidence is not allowed to prove in this proviso. And the other condition is that this document, this original document, should not be formal. That should not be extremely formal. अब certain documents are very formal, like इंश्योरेंस का एग्जाम्पल दिया था हमने। आप कहीं मेडिकल ट्रीटमेंट करवाने जाओ तो उसमें सारे टर्म्स बहुत डिटेल में लिखे होंगे, एंड दे विल मेक यू साइन अप ऑन इट। सर्जरी आपकी हो रही है तो उसमें बहुत लंबा चौड़ा फॉर्म लेके आएंगे, इंश्योरेंस के, हायर परचेज के एग्रीमेंट वगैरह, ये सारे बहुत डिटेल में होते हैं। So these are very formal documents, and they are, even if the document is silent upon something, so it will not be a case, a mistake where the parties are silent upon. It would be considered deliberate silence, and therefore you cannot say that on that point we have entered into an oral agreement. So insurance contract में every details they are writing every possible details. अगर कोई इसको डिटेल में पढ़ ले एक बार तो इतनी डिटेल्स होती हैं कि आपको खरीदने का मन नहीं करेगा मोटर व्हीकल या इंश्योरेंस का, क्योंकि नॉर्मली जब भी हम इंश्योरेंस कराते हैं हम इतना टाइम नहीं होता, इतना डिटेल में हम उसको पढ़ते नहीं हैं। तो जब क्लेम व्लेम लेने जाते हैं तब उधर ऑब्जेक्शंस आते हैं, तो वो सारी चीज़ उसमें रिटन होती है, क्योंकि अगर कोई शुरुआत में पढ़ ले तो ऐसा लगेगा आपको जैसे वो बेवकूफ़ बना रहे हैं। तो उस केस में अगर वो साइलेंट है इस तरीके के एग्रीमेंट्स में, तो उसमें ओरल एविडेंस अलाउ नहीं होगा किसी एग्रीमेंट के लिए, किसी पॉइंट के लिए। And if there has to be something, then it has to be reduced into writing. And if not reduced, अगर oral agreement कर भी लो, then it will not be allowed to be proved. अब दो कंडीशन हो गई। पहला जो oral agreement किया आपने, that should not be inconsistent with the terms of the written contract or agreement, with the terms or spirit of the agreement, main agreement. Then other one is if the document is हाईली फॉर्मल। अब ये प्रोवाइजो आप ढंग से पढ़ना। द रीजन बीइंग इज दैट जब आप लिस्ट्रेशन पढ़ोगे ऑल दीज प्रोवाइजो आर एप्लीकेबल। नाउ लेट्स सी द प्रोवाइजो 3। नाउ सी द प्रोवाइजो 3। द एग्जिस्टेंस ऑफ एनी सेपरेट ओरल एग्रीमेंट constituting a condition precedent to the attaching of any obligation under any such contract, grant or disposition of property may be proved. What they are saying by this? They are saying, suppose A और B के बीच में कोई कॉन्ट्रैक्ट हुआ, there is a contract between A and B and the contract is documented, उसमें बहुत सारी चीज लिखी है, सारे टर्म्स लिखे हुए हैं, और पैरेलल में इन्होंने एक ओरल एग्रीमेंट किया, they have got into an oral agreement parallelly under which they have put a condition precedent, then that condition precedent, that oral agreement can be proved. अब what is condition precedent? Condition precedent means a condition जिसको आपको पहले फुलफिल करना पड़ेगा तभी कॉन्ट्रैक्ट एनफोर्सेबल होगा। पहले आप इस कंडीशन को फुलफिल करोगे, टर्म को फुलफिल करोगे, तभी आपका कॉन्ट्रैक्ट एनफोर्सेबल होगा। कंडीशन प्रेसिडेंट मीन्स देयर इज अ कंडीशन Unless you fulfill that condition, the contract cannot be enforced. Now suppose if I buy a house, A buy a house, and A put a condition precedent that get the house painted before I take the possession, and the intention at the time putting that condition is that I will not buy your house unless you get it painted, then the painting of the house will be the condition precedent in this condition. सिमिलरली उसी तरीके से ये हाउस खरीदना चाह रहा है, उस पर कुछ ड्यूज हैं, बी बेच रहा है, तो उसमें कंडीशन प्रेसिडेंट कर दी दैट फर्स्ट ऑफ ऑल यू हैव टू क्लियर योर ड्यूज ऑन द अपॉन द हाउस, एंड इट वाज द इंटेंशन एट दैट टाइम कि इफ यू नॉट क्लियर द ड्यूज आई विल नॉट बाय इट, देन इट वुड बी द कंडीशन प्रेसिडेंट इन दिस केस. और ज़्यादा डिटेल में आप कंडीशन प्रेसिडेंट, कंडीशन सब्सिक्वेंट कॉन्ट्रैक्ट क्लासेस में पढ़ोगे. अब in this proviso they are saying is there is a contract and there is no condition precedent written in the terms of the contract, but parallelly the party went to a condition precedent. Then to prove that condition precedent, oral evidence can be given. So for that this oral evidence can be given. Read it again. The existence of any separate or oral agreement constituting a condition precedent to the attaching of any obligation under any such contract, grant or disposition of property may be proved. मतलब ए और बी के बीच में एग्रीमेंट हुआ, अब उस कॉन्ट्रैक्ट में ऑब्लिगेशंस क्रिएट होंगे और बी दोनों के ऊपर, लेकिन उन ऑब्लिगेशंस के क्रिएट होने के पहले, उन ऑब्लिगेशंस के क्रिएट होने के लिए एक कंडीशन पे एग्री कर लिया इन्होंने ओरली कि जब तक ये कंडीशन फुलफिल नहीं होगा तब तक द पार्टीज विल नॉट बी लायबल टू फुलफिल देयर ऑब्लिगेशंस. सो दैट इज व्हाट कॉल्ड कंडीशन प्रेसिडेंस. सो oral evidence for proving the oral agreement is allowed to be given because that completes the contract, because that is not the variation of the terms or material terms, that is only a putting of a condition. So the oral evidence for that is allowed to be proved. Now see the proviso 4. The existence of any distinct subsequent oral agreement to rescind or modify any such contract, grant or disposition of property may be proved except in cases in which such contract, grant or disposition of property is by law required to be in writing or has been registered according to the law in force for the time being as to the registration of documents. Read again. The existence of any distinct, they are using the word distinct, subsequent oral agreement. And this word distinct and subsequent is important. The existence of any distinct subsequent oral agreement to rescind. Rescind means what? To take back, to withdraw, to rescind or modify any such contract. या तो कॉन्ट्रैक्ट को रिसाइन कर दिया, पहले तो रिटर्न में एग्रीमेंट कर लिया और बाद में दोनों ने ओरली एग्री करके कॉन्ट्रैक्ट को रिसाइन कर दिया, या फिर कॉन्ट्रैक्ट को रिसाइन नहीं किया, उसके किसी टर्म को रिसाइन कर दिया. जैसे पहले एग्रीमेंट था कि आप मेरे को मकान और ज़मीन दोनों मुझको बेचोगे, और अब हमने ज़मीन वाली बात को रिसाइन कर दिया, अब एग्री हुए सिर्फ मकान बेचने के लिए. सो दे एग्री to rescind the entire contract, or the parties agree to rescind some terms of contract. The existence of any distinct subsequent oral agreement to rescind or modify means to change, modify any such contract, grant or disposition of property may be proved except in cases in which such contract, grant or disposition of property is by law required to be in writing. तो ये होगा 91 का जो पार्ट 2 वाला मैटर, ये रिक्वायर्ड टू बी रजिस्ट्रेशन हुआ ना, कॉन्ट्रैक्ट, ग्रांट और डिस्पोजिशन रिक्वायर्ड टू बी रजिस्टर्ड. सो रिक्वायर्ड टू बी इन राइटिंग, बाय लॉ रिक्वायर्ड टू बी इन राइटिंग, और हैज been registered according to the law in force for the time being as to the registration of documents। मतलब उस ग्रांट, कॉन्ट्रैक्ट और डिस्पोजिशन को राइटिंग में रिड्यूस करना जरूरी था, या फिर उसको एक्चुअली आपने रजिस्टर कर लिया है। रिकॉर्ड करना जरूरी था और एक्चुअली आपने मान लो उसको रजिस्टर कर लिया। तो कॉन्ट्रैक्ट तो वैसे तो आपने राइटिंग में किया, बट जो टर्म है एग्रीमेंट का कुछ, उसको आपने ओरली कर लिया, लेकिन लॉ कहता है द कॉन्ट्रैक्ट शुड बी इन राइटिंग। तो ऑब्वियसली अगर ओरल एग्रीमेंट अलाउ हो जाएगा प्रूव करना, देन इज इट नॉट द वायलेशन ऑफ लॉ? लॉ सेज दैट कॉन्ट्रैक्ट शुड बी इन राइटिंग। Parties entered into a contract into writing, but some terms they are done in orally। तो orally कैसे कर सकते हैं? Because law requires that the contract should be in writing, so not only the main contract, then the associated terms also should be in writing। That is one thing, and the second thing, if it was required to be registered and you actually got it registered, तो रजिस्टर कर लिया, अगर उसके टर्म में बाद में आप चेंज करोगे तो उसको भी आपको रजिस्टर करवाना पड़ेगा, खाली राइटिंग से भी काम नहीं चलेगा। तो यहाँ पे लॉ आ गया ना बीच में। लॉ कहता है दैट इट शुड बी इन राइटिंग और इट शुड बी रजिस्टर्ड। लॉ रिक्वायर्ड इट शुड बी इन राइटिंग और इट शुड बी रजिस्टर्ड। देन वहां पर नथिंग कैन बी इन ओरल, एवरीथिंग शुड बी इन राइटिंग। But if that is not the case, that contract is not required to be in written or to be registered, and then you convert it into document, and thereafter if you entered into a distinct subsequent oral agreement to alter or to resign some term of the contract, then that agreement can be allowed। जो कंडीशन है कि ये डिस्टिंक्ट होना चाहिए और सब्सिक्वेंट होना चाहिए, क्योंकि आप कंडीशंस देखो, अभी तक आपने क्या पढ़ा है? पहला तो आपने पढ़ा जहाँ पे वॉइडेबल वाला मैटर हो, इलीगैलिटी वाला मैटर हो, उसके लिए आप ओरल एविडेंस दे सकते हो। दूसरा आपने पढ़ा इफ द डॉक्यूमेंट इज साइलेंट अपॉन समथिंग एंड द डॉक्यूमेंट इज नॉट फॉर्मल ऑल्सो, तो उस पॉइंट पर कोई अगर ओरल एग्रीमेंट है तो आप उसको प्रूव कर सकते हो अगर इनकंसिस्टेंट नहीं है। तीसरा आपने पढ़ा इफ द डॉक्यूमेंट इज साइलेंट अपॉन कंडीशन प्रेसिडेंट and you have entered into oral agreement upon or regarding that condition precedent। Means condition precedent, document being silent and the document not being a formal document and the illegality वाला matter। अब now what you are reading is, क्योंकि अभी तक आपने कहीं पे भी terms of contract resigned करने की बात नहीं पढ़ी है, rescinding और modifying the terms of contract। तो अभी तक हम जो ओरल एग्रीमेंट है वो फिल इन द ब्लैंक्स के साथ पढ़ रहे थे। फिल इन द ब्लैंक्स मीन्स व्हाट? जैसे डॉक्यूमेंट इज साइलेंट, इफ ऑन ए मैटर इट वाज साइलेंट देन इट इज ओरल एग्रीमेंट। इफ ए डॉक्यूमेंट इज साइलेंट ऑन कंडीशन प्रेसिडेंट ऑन दैट द ओरल एग्रीमेंट इज गिवन। अब किस मैटर प्रेसिडेंट पे साइलेंट है? सो अभी तक जो ओरल एग्रीमेंट है वो दैट इज मोर ऑफ ए फिल इन द ब्लैंक्स। लेकिन अब इस सिचुएशन में डॉक्यूमेंट इज क्लियर हैविंग ऑल टर्म्स and now you are altering the term of a document and resigning the term of document, तो यहाँ पर fill in the blank नहीं है। So actually you are changing the document by entering into the oral agreement। So therefore the fourth proviso is important, क्योंकि proviso 1 और 2 और 3 तो फिर भी common sense से समझ में आता है जो conditions है उसकी, but proviso 4 में एक बार आपने जो conditions लिख दी तो उस terms को alter करने के लिए then the oral agreement will not be allowed। सॉरी, oral agreement आपने उन terms को alter करने के लिए किया है और उसके लिए oral evidence allow नहीं होगा, क्योंकि आपने उस डॉक्यूमेंट के टर्म्स को रिसाइंड करने के लिए oral agreement किया है, that is opposite to the terms। But in earlier proviso there it was complementary to the document, particularly proviso 2 or 3, that is oral agreement is complementary to the main agreement in proviso 2 3 mainly, but in fourth one it is not complementary, it is opposite to the main contract, because you have written something and orally you have agreed that no, it should be something else. You are assigning it or changing it. So here, whatever the oral agreement is done, the gist of it is against the spirit of the document. It is against the document, and that is where there you see in section 92. If you directly see in the section 92, ऐसा एविडेंस, ऐसा एग्रीमेंट अलाउ नहीं होगा, और प्रोवाइजो 4 कह रहा है कि ऐसा एग्रीमेंट अलाउ होगा। तो यहाँ पर आपको थोड़ा सा प्रिकॉशन लेना पड़ेगा। क्योंकि प्रोवाइजो 4 92 को के सेक्शन 92 का डायरेक्टली उसका उल्टा दिखता है। तो सेक्शन 92 तो कहता है हमारा वेरी रिसाइड वगैरह के लिए, सब्सट्रैक्शन वगैरह के लिए आप कोई ओरल एविडेंस नहीं दे सकते हो। और यहाँ पर ये कह रहे हैं आपने अगर किसी टर्म को भी वेरी कर दिया, रिसाइंड कर दिया, उसका भी ओरल एविडेंस आप दे सकते हो। वो आप एक ही केस में दे सकते हैं। आपको लैंग्वेज ध्यान से देखना पड़ेगा, आपको इसका डिफरेंस समझने के लिए। वो आप एक ही केस में दे सकते हैं जब आपने कोई कॉन्ट्रैक्ट किया यहाँ पर, और जब आपने कॉन्ट्रैक्ट किया टर्म्स लेके, उस समय आपके कोई कंफ्यूजन नहीं था आपके बीच में, एवरीथिंग वाज फाइन। उसके बाद द ट्रांजैक्शन ऑफ द कॉन्ट्रैक्ट वाज ओवर, द ट्रांजैक्शन ऑफ कॉन्ट्रैक्ट गेट ओवर, एवरीथिंग इज सेटल्ड नाउ। A and B entered into a contract, everything was settled, and they are reduced it into the writing. After that, not contemporaneous, they are writing distinct subsequent. After that, after the original transaction is over, after that maybe you meet once again somewhere and another idea comes that the term in that contract is not proper. I think we should alter that. तो कोई भी ऐसा टर्म है, अब वो ट्रांजैक्शन तो खत्म हो गया है, कॉन्ट्रैक्ट अभी परफॉर्म नहीं हुआ है, कॉन्ट्रैक्ट हैज टू बी परफॉर्म्ड, कॉन्ट्रैक्ट अभी साइन ही हुआ था, लेकिन द ट्रांजैक्शंस ऑफ नेगोशिएशंस आर ओवर because the contract was signed, and thereafter distinctly, the word distinct I trying to explain you. Distinct means distinct from that transaction. If fresh transaction starts, means if you again meets and one of you says that I think that one of the terms should be altered, and both of you orally agrees to the alteration of that term or rescinding of that term. अब suppose example A and B agreed to sale and purchase of a house. A is purchasing the house of B, and the condition put by A that you shall paint your house first, and then I should purchase your house. B shall get his house painted, and then only the A will purchase the house. तो condition precedent लगाया, and that is reduced into writing in document. अब मान लीजिए मे बी ए पर्टिकुलर ईयर की विंटर्स में वो घर खरीदना था, ए को लेना था, और विंटर से पहले सितंबर अक्टूबर में मान लीजिए, और जून जुलाई में इट वाज वेरी हैवी रेनिंग। बी को वो पेंट कराना था, एंड गेटिंग द हाउस पेंटेड वाज नॉट पॉसिबल बिकॉज ऑफ द वेट कंडीशंस। और नाउ समवेयर ए एंड बी मीट्स, और जो टाइम था वो सितंबर का था, and they said that the painting is not possible because of the weather condition. So can we withdraw that condition? Then again they agree. A agrees and said, okay, fine, let us not get it painted, and you give me the money of the painting, or not to give without money also agreed, and agrees that I will get it painted myself later on. अब इसमें नया ऑल्ट्रेशन कर लिया उन्होंने, पेंटिंग का कंडीशन विड्रॉ कर लिया और एक नया कंडीशन डाल दिया कि उसके पैसे ऐड कर दो और कंसिडरेशन अमाउंट बढ़ा दिया थोड़ा सा, या फिर ए को जो पैसे देने थे बी को उसमें से कुछ पैसे पेंट के उसने काट लिए, या फिर पैसे पहले मिल चुके हैं उसको बी को, तो अब बी को लौटाने पैसे कुछ। अब लेकिन बाद में जब कॉन्ट्रैक्ट परफॉर्मेंस की बात आती है then there is dispute between the two, and B is refusing to pay the money. Now here A want to prove that along with the document that there was an oral agreement also, but it was not then when the contract was done. It was distinctly and subsequently because of some change in conditions. It was distinct. ट्रांजैक्शन तो पहले हो गया था कॉन्ट्रैक्ट का, कॉन्ट्रैक्ट ऑफ नेगोशिएशन का, और अब तो हमने नया एक एलिमेंट ऐड कर दिया है डिस्टिंक्टली। तो इस तरीके के केसेस में प्रोवाइजो 4 विल अप्लाई। लेकिन अगर आप उसी कॉन्ट्रैक्ट की कंटिन्यूटी में उसी ट्रांजैक्शन में अगर ओरल एग्रीमेंट करते हो, कोई कंटेम्परेरियस ओरल एग्रीमेंट करते हो टू रिसाइड द टर्म और टू चेंज द टर्म, दैट इज समथिंग स्पेसिफिकली रिटन इन द डॉक्यूमेंट, उसको अगर आप चेंज करना चाहते हो, then that will not be allowed. It will be allowed only if the transactions of the original negotiations is over. Subsequently, due to some conditions, they again set to be negotiation for the negotiation, and then they agreed to change the terms of same contract. अब मान लो A और B ने agree किया कि I will purchase your house for 50 lakh rupees, and the contract is signed, and later on B again meets A. Look, that there is a small piece of land at the back side of your house that belongs to you. You please give that land also to me as a part of the transaction, because that land is very small piece of land, but that would be very helpful for me. And the A on that says fine, I will promise that I will give you that land also. अब कॉन्ट्रैक्ट में रिटन में जो लैंड की बात नहीं लिखी हुई है, दे हैव एग्रीड ओरली। हालांकि ये एग्जाम्पल सूटेबल नहीं होगा क्योंकि ये मूवेबल प्रॉपर्टी है तो इसका रजिस्ट्रेशन जरूरी होगा, बट सपोज क्योंकि अगर रजिस्ट्रेशन जरूरी है तो रिटन होगा ही होगा, और रजिस्ट्रेशन जरूरी होगा तो रिटन है और रिटन के बाद रजिस्ट्रेशन है। तो अगर रजिस्ट्रेशन जरूरी होगा तो प्रोवाइजो 4 में क्लियर लिखा है कि फिर आप ओरल एविडेंस नहीं दे सकते हो। लेकिन बस समझाने के लिए सपोज, तो आप समझ ही गए होंगे वैसे कि अलग से आपने अगर कोई एग्रीमेंट किया है उसका आप प्रूफ कर सकते हो, बिकॉज दैट इज नॉट ए कंटेम्परेरियस एग्रीमेंट। सो बेसिकली द पॉलिसी ऑफ दिस प्रोवाइजो इज कि अगर आप कंटेम्परेरियसली ओरल एग्री करते हो, सो ऑब्वियसली व्हेन यू आर डॉक्यूमेंटिंग इट यू कैन ऑल्सो डॉक्यूमेंट that term also for which you are contemporaneously agreeing. Why you have not write it? So there is a doubt regarding the contemporaneous agreement. But at times what happen is when the initial documentation is done and later on you negotiate on something, you meet somewhere formally and you agree for that, and you do not need to bring about the change into the document. You are not having the original document to bring about the change in that, and therefore it is possible that when you subsequently and distinctly when you entered into a oral agreement, you may not have the document to bring about the change. But if that oral agreement is proved clearly, then obviously you will be allowed to prove. But if it is required by law to be in writing, or it is required by the law to be registered, then the oral evidence will not be allowed. So write it down. For Proviso 4, it is essential that the transaction of the original contract was completed. The moment the parties concerned have got the contract documented and have put signatures on it, it will be said that the transaction of that contract is completed. And thereafter, next sentence, thereafter if the party again sit together after some time gap, here it means distinct and subsequent, after some time gap, and get into some fresh negotiation, in order to add or to alter or to resigned some term of the said contract, and if they do so orally, then it will be said that it was a distinct and a subsequent oral agreement, and such agreement will be allowed to be proved as per Proviso 4. However, the transaction should not be such as it required by law to be in writing, or it should not have been registered, or the document should not have been registered, or the document should not have been registered. क्योंकि अगर रजिस्टर्ड आपने कर लिया तो जो भी अल्ट्रेशन होगा तो वो भी आपका रजिस्टर्ड होना चाहिए। और अगर लॉ कहता है दैट इट शुड बी इन राइटिंग, तो ओरिजिनल डॉक्यूमेंट प्लस एनी एडिशनल oral agreement, original document plus any additional agreement, all that should be in writing. So in those cases, this proviso will not apply. So that's it for this proviso. And for this lecture, we would continue the proviso 5 and 6 into the next lecture and also see the illustrations. Thank you for watching this lecture.